I want to introduce our co-host for today. Thank you for inviting us to present with you today. This is Diane Skinner from Artemis Lifestyles, and Diane is a very important person there. She is the Director of Management Services. Diane, please tell us a little bit about yourself and Artemis Lifestyles for those who don't know you.
All right, I would love to. Good morning, everyone. Thank you for joining us for this class. We appreciate you all and your attention today. Artemis Lifestyles is a full service management company. So we have HOAs, condos in our portfolio. We're located in Central Florida. So we cover all of Central Florida, East Coast and West Coast. I'm located on the West Coast myself, so I'm in the Tampa area. Our tagline is love where you live and love where you work. So it's important to us to please our homeowners as much as possible, our board members. In doing that, we have a whole lifestyle component, hence our name, Artemis Lifestyle. So we have a lifestyle director. We offer programs and events and activities for our communities as much as you want. I mean, we can put on a fireworks show and have bounce houses or whatever your community desires as far as activities and events. So that's a big focus of ours, and kind of what sets us apart from other management companies is that we can offer some fun, to your community. So if you are interested in, a management company, we are happy to speak to you, send out a proposal, and start that process for you. So thank you, and I'll turn that back over to Jeff.
Thank you very much, Diane. Great to see you as always. And Kerstin, before I'm going to do a little more housekeeping. We're getting some funny comments in the chat that you're not looking pink and purple today. That's great. So it's nice to have our regulars back. Thanks for joining us today. As we see, about 30 or 40 more of you have joined while Diane was doing her wonderful introduction, telling you about the great services Artemis offers, as well as gracing us with her beautiful smile. We had more join us. So keep in mind that if you haven't already activated the chat, press the chat button one time so it appears. We'll place the evaluation link there a little bit later. And just a quick rundown. When you click on the link towards the end of the class, again, it's not there yet. We'll place it there a little bit later. You'll fill this sucker out. I'll go over it much more slowly later, I promise. And after you submit it, the confirmation screen looks like this. And listen up, because this is something I know some of you are going to ask later, so please listen to what I'm saying now. You don't have to take crazy copious notes today, because you will be able to get today's slides after you fill out the evaluation. So this confirmation screen has several bullet points: Artemis's contact information, the firm's contact information, Kerstin's contact information. This last bullet point, download the slides. You'll be able to click on it, download them, and save them a little bit later. Again, I'll go over that much more slowly in a bit. So with that said, I'm going to turn it over right now to our managing partner. She manages the Tampa office of Kaye Bender Rembaum. I call her, she's probably tired of me saying this, the walking encyclopedia, because she knows these answers pretty much just like that. This is Kerstin Henze, again, from our Tampa location. Kerstin, please take it away, my friend.
Awesome. Thank you. Thanks, Diane, for joining us. Thanks, Jeff. For those of you who attended the webinar I taught earlier in the week, for some reason, my camera went pink. And so I was pink the entire time. So that's the reference to me being pink in that webinar. The camera seems to be working fine today, although I don't know, it's temperamental, so it could turn pink or purple at any point. I apologize. All right. So again, I'm Kerstin Henze. I am a partner managing attorney with the law firm of Kaye Bender Rembaum. I manage the West Coast office for the firm, which is located in Tampa. But, we are a full service community association law firm. So we represent community associations, your HOAs, your condos, and your co-ops throughout the state of Florida. If you are on the West Coast, then probably my office will be the closest to you. I have been practicing law for 17 years, and I've been with the firm since 2010. So virtually my entire career has been practicing law in this particular area of the law. All right, let me go ahead and share my slides. All right, we're going to talk about screening buyers, tenants, and then occupants. And as Jeff mentioned, you will be getting copies of all of these slides. All right.
Correct. And the video will be on kbrlegal.com within a few business days as well to review afterwards.
Provided I'm not pink.
Provided you're not pink, in which case we'll just put the audio.
All right, can you see these slides?
Not yet.
You can't see the slides?
No, wait a minute. Let me see here. I'm not seeing them yet.
I see, yes, I can see it.
You guys see them? Okay. Then it must be something funky going on with on my end, but we're good to go if you can see them. William in the chat says he cannot see the slides.
Cannot see. Okay. Let's do this again.
I'm going to get them ready on my end here just in case there are tech issues there, and I'll end up sharing them if need be. There we go. Looks like it's happening now.
Now?
Yep, now we see them.
Perfect.
Perfect.
Okay, here we go.
You're a tech wizard.
All right, so what we're going to cover today is the process of screening not only new owners, so purchasers who buy into your community, tenants, and then we'll also talk about guests and additional occupancy restrictions, because those are the types of occupants or residents that typically do not fall, they're not categorized as owners, they're not categorized as tenants, and then they seem to fall through the cracks, right? So we'll talk about options in controlling occupancy, managing occupancy of these particular individuals in your community. All right. Well, what can we even restrict and why? So if we're talking about controlling, access and occupancy into your community, then there has to be specific authority authorizing the board to control access, occupancy, and conduct of these individuals, right? So Florida statutes 718, 720, and 719 don't really address the specific issues we'll talk about today. Not in their entirety. Okay. And so when we're talking about authority, you really have to look at your governing documents to confirm what authority you have with regards to these individuals. Okay. So what are your governing documents? So I just want to briefly, go over what they are. Your governing documents are going to consist of primarily either your declaration of condominium or your declaration of covenants if you're in an HOA. It's also going to include your articles of incorporation and bylaws. Now, you might have rules and regulations, but they're typically not considered part of your governing documents. Now, among your governing documents, your declaration is going to be your supreme document, right? So in terms of hierarchy, your declaration is going to have priority. It is the document that is going to contain your use restrictions, right? It is the document that's going to outline what you are authorized and not authorized to do as an association. It is the contract between the association and owners who purchase, in your community. And so that is the primary document that really should be containing or addressing the screening of your buyers, of your tenants, and then any additional occupancy restrictions. Now, your articles of incorporation and your bylaws, well, these are the documents that set up your corporate structure of your association. As many of you are aware, your association is a corporation, right? So it's a not-for-profit corporation that's governed under Chapter 617 of the Florida statute, but nevertheless, it is an entity, right? And so when your developer created your community, the developer created these articles of incorporation that were filed with the Division of Corporation in Tallahassee. And it basically outlines, who qualifies to be a member of your association, who qualifies as a director, how many directors do you need to have on the board. And the bylaws really are just an extension of your articles of incorporation. So it's going to have a little bit more of the meat and potatoes of your corporate governance. So when we talk about use restrictions and the authority to do or not be able to do certain things, these covenants really should be contained in your declaration, not in your articles, not in your bylaws, and certainly not in your rules and regulations. Okay, so the declaration is what we're going to be focusing on for the rest of the slides. Okay. Now, once we now that we've established that the declaration is going to be your primary document, these are the items that we're going to primarily look at in your declaration, right? With regards to buyers, tenants, and occupants. So the first thing is you're going to confirm in your declaration, do you have the right to approve or disapprove buyers, tenants, or occupants? Okay, is there specific authority? And we'll talk about that specific authority in some of the later slides, but one of the things that the specific authority to approve and disapprove buyers has to contain is a right of first refusal. And we'll talk about that in a few slides. But again, you're specifically looking at the declaration to see if you have the authority. Now, if you have some of the older documents and you don't have the specific authority to approve or disapprove certain types of conveyances and transactions, then this is probably something that you might want to consider discussing with your legal counsel and looking to amend your declaration to give you that specific authority. Now, in connection with the sale and lease approval, you might want to consider or see if you have the authority to charge what is known as an application or a transfer fee. Okay. Now, with regards to condominium associations, the Chapter 718 of the Florida statute specifically addresses application or transfer fees, and it essentially provides that if your governing documents give you the authority to charge this application fee, then you can do it. And right now, the maximum amount that you can charge is $150 per applicant. Now, spouses are considered one applicant as well as parent dependent child. Okay, but this application fee is supposed to cover essentially the background check. And we'll talk about background checks in a few slides. But essentially, once an applicant submits an application, typically you'll run a criminal and or credit background, and so this application or transfer fee is going to cover that background investigation. But again, you would only be able to charge an applicant for this fee if it's in your governing document. So if you currently don't have that authority to charge this fee, then again, you should be considering amending your documents to give you that specific authority. Specifically with rentals, again, you want to look at your governing documents. Do you have the ability to charge a security deposit? Now, the security deposit is intended to protect against damage to the common element or the common areas caused by either the tenant or a family member of the tenant or a guest or invitee of the tenant, right? It's not really intended to cover unpaid, delinquent assessments or fines or any other charge other than damage caused to the common elements or common areas by the tenant or their guests or invitees. With regard to the condominium statute authorizes associations to charge a security deposit, provided that authority is, again, expressed in your governing document. So again, while the statute gives you that entitlement, the specific authority has to be in your governing document. And more often than not, you'll find this, or you should be adding this authority in your declaration. Now, Chapter 718 of the Florida statute also provides a limitation of how much you can charge for a security deposit, and it typically cannot exceed 1 month's rent. Okay, and that security deposit would have to be then placed in escrow, and again would only be used if once the tenant vacates, if there's any damage that's documented by the association, you would be able to use that deposit to cover some of the damage. Okay, hopefully all of it. If not, the owner remains responsible for the conduct of the tenant. And then certainly if there is no damage, then the association would have to return that security deposit to the tenant, right? And then Chapter 83 of the Florida statute is what would govern the process of returning the security deposit to the tenant, right? That's the landlord-tenant statute. And Chapter 718 does refer back to that landlord-tenant statute with regards to this security deposit. Now, another thing you might be looking for in your governing documents, and if you don't have it, you might want to consider amending, down payment requirements. So this refers to, your ability to require prospective purchasers to make certain down payment. So you might require that owners, pay either 10% or to provide a 20% down payment, right? To have some equity in the unit. Again, that's not something that you're going to be able to compel as a policy or as a rule. Okay, so if your documents don't currently contain such a requirement, you might want to consider adding it as an amendment. So definitely encourage you to speak with your legal counsel about drafting the language for this particular provision. Move in or move out deposit. Okay, so you might want to have a requirement for owners, potential owners or tenants to provide a deposit that is intended only in connection with the move in, move out process, right? So in the event that they're moving heavy furniture and they scratch the freshly painted walls in the hallway or dent the elevator, this deposit is intended to cover, that particular damage. So a little bit different from the security deposit that would cover any potential future damage during the term of the tenancy. So again, I would encourage you to, review your documents, and if you don't have specific authority to address move in, move out deposits, then, consider an amendment. Right, moving on. All right, so we've talked about the authority to for the association to be able to do certain things, right? Now, with regards to transfers, what transfers are subject to approval, right? And typically the sales and leases are the most common that come to mind, right? But there are others. And your documents, your declaration may or may not necessarily address these other types of transfers or conveyances. And so this is something that you might want to consider reviewing with your legal counsel, and certainly review it internally with the rest of your board members. And think, do you want to try to control these other types of conveyances? Okay, or not. So the most typical transfer conveyance that that you would see in a typical declaration is the ability to approve or disapprove sales, your arm length sale transactions, right? These are your typical sales. There's a title company involved, there's a closing, and then the owner takes title to a unit, right? That's your traditional sale. If you have the ability to approve or disapprove sales, fantastic. If not, you might need to amend your declaration to give you that authority. But what about other conveyances? There's gift conveyances, devises, life estate deeds, even trusts. Okay, so A gift conveyance, for example, is one where, unlike a traditional sale, let's say the record owner purchases the property in his or her name individually, and then decides later on to add someone else on the deed, perhaps a spouse or perhaps, a family member. So they just add someone else to the deed. Well, typically, this is done via quitclaim deed that is recorded in the public records with minimal consideration, right? So typically, these types of conveyances are considered quitclaim. These types of conveyances are considered gift conveyances. Okay. Life estate deeds, typically, these are deeds that are done as part of estate planning. So the current record title owner basically creates a deed where they retain interest in the property for as long as they live, but upon their death, title in the property will automatically go to whoever they've named in that deed, right? So that upon the death, whoever they named in the deed would basically, inherit, take title to the property without having to go through probate in court, right? So that is a very common estate planning tool. And then trusts are also common for estate planning purposes. This is where the record title owner essentially conveys title in the unit to a trust, to a trustee. Typically, the deed will name the individual that is the trustee of the trust, and they are the ones that will be managing title to the unit and potentially, other property for the owner. But for purposes of what we're talking about here, the question to you is, do you want to have the ability to control these, these other conveyances? So if an owner decides to add someone else to their deed, do you want to have the ability to screen this additional owner, right? And so your documents may or may not address this at this point. And so this is, again, just for you to consider when you're reviewing your documents and potential areas of amendment. There could be transfers by operation of law, right? Intestate, if an owner dies without a will, whoever the beneficiaries or some other individual inherits title to the property. There could be entity dissolutions or mergers. This would come up, for example, if title in a unit or property is in the name of an entity, right? Unless your documents expressly prohibit entities from owning title to property in the community, they can do so. And if there is a merger of the entity or some kind of dissolution, right, then potentially title in that particular property, is transferred. And so your documents may or may not address that potential transfer. Or what about foreclosures? Mortgages, if there's a delinquency on a mortgage, mortgagees can foreclose title, right? And mortgagees can take title to a unit. Well, typically, if a mortgagee takes title to a unit, that transfer is not necessarily subject to board approval. But you might have governing documents that say if that mortgagee later decides to sell the unit or the property or decides to lease that property, that transaction is not subject to board approval. Or it might say it is. Okay, but if your documents currently exempt those conveyances from the mortgagee, you might want to consider amending your documents not to exempt those transactions. Okay, so that, once the mortgagee takes title, remember, a mortgagee that takes title to a property becomes like any other owner, right? And so they do have the ability to sell and lease the property. And so if you want to be able to capture, these occupants, from either the sale or the lease from that mortgagee, then you need to have specific authority in your declaration to address, those types of conveyances. Okay. Leases are another type of transfer of interest or possession in the unit that could be subject to approval. Okay, so if an owner wants to lease their property, you would have to, you'd have the ability to do a background check on the tenants and any additional occupants that will be residing with the tenant, and then, render an approval or disapproval. And then there is, additional occupancy, additional family members and even guests, right? These are all types of occupants or residents that come into play after you have approved the initial sale or the initial lease. So typically this might come up in a scenario where you've approved the owner that has just bought the property, or you've approved the proposed tenant, and 6 months down the road they have a family member, or they have some other occupant come and stay with them, right? And for most associations, they typically, boards don't typically have an issue with occupants, with these additional occupants or guests occupying the property for a limited period of time. But then when this occupancy turns into, 3 months and then 6 months, right? The question to you is, well, what do you want to do with these occupants, right? Do you want to prohibit certain occupancy after a certain period of time? Do you want to require these occupants to go through the approval process that tenants and owners or prospective buyers are subject to? Does it matter whether the owner or the tenant is residing in the unit with these additional occupants? Do you want to, prohibit occupancy of these additional occupants when the owner or tenant are not in residence? And I'm not talking about, the owners decide to go on a cruise for a month. I'm talking about a situation where, the original owner or the tenant is absent for a significant period of time. Do you want the unit to be occupied by guests or other family members that haven't been vetted? Okay. Do you want to perhaps, provide exceptions to family members? Okay, so if they're immediate family members of the owner or of the tenant, perhaps they're allowed to reside in the unit for a certain period of time. But after that, they might have to go through the approval process. These are just some ideas, some thoughts that you might want to consider in how you want to address these guests, additional occupants, and family members that come into the picture after the initial approval has been rendered, whether it's of an owner or of a tenant. All right. And so now that let's assume that you've established that you do have the ability to approve and disapprove certain types of transactions, right? Your sales, your gift conveyances, and your leasing, okay, and potentially even additional occupants. Well, what can you do? Well, the screening process really starts with an application process, right? And typically, if you are managed by a management company, the management company will assist with this application process. But it typically starts with the association being notified that an owner wants to sell their unit or wants to lease their unit. And then there's a request made for the application. Okay, you provide the application and the applicant has to fill this out, right? And provide certain information on that application. Typically, the application will request the applicant to identify all additional occupants that will be occupying the property with the applicant. There would be typically a request for residential history, some character references. Typically, an application will require the applicant to acknowledge that they've received and reviewed certain rules and regulations and perhaps some covenants in the declaration. And then the application will also typically include a form for the applicant to consent to a criminal or credit background check, right? This is where the transfer or application fee comes in, right? Because if you have the authority to charge that fee, then typically your application will require the applicant to submit payment along with their completed application so the association can then process it and run the background checks through typically a third party source. So you've received the application, and we'll talk about this particular point later on, but you'll want to make sure that you're familiar with the timelines that should be set forth in your declaration as to when you have to provide the applicant a response, a decision on the application. Okay, so I have seen documents that might require, a 10-day turnaround all the way to 45-day turnaround. So you want to check your documents and confirm what that time period is, because typically documents are written by developers, and even amendments are written in a way that if you miss the deadline and if you don't provide an approval or disapproval within that particular time frame, then the applicant is deemed approved. Okay, so you don't want to be in that position, right? So as soon as you have received the completed application and the background check, that's when the time clock starts ticking. So you want to make sure what that time frame is so that you do provide a timely response to the owner. All right, so you reviewed the application, and now what are your options? Well, you can approve the transaction. You can disapprove the transaction on good cause basis, and we'll talk about that in a minute. Or you can exercise a right of first refusal. Okay, so let's go back a little bit. Your declaration, and if you don't currently have it, I strongly recommend that you amend your declaration to include good cause criteria. These are the criteria or the bases that you as a board are going to be reviewing and determining on whether or not this particular applicant, qualifies to own and certainly reside in your community. The good cause criteria should really be in your declaration. If you don't have the good cause criteria in your declaration expressly outlined, provided you have the ability to approve and disapprove these types of conveyances and transactions, and you have rulemaking authority, you might be able to adopt as a rule what your good cause criteria are. And the reason it's important that you have these good cause criteria outlined is because if you do end up disapproving an applicant, okay, having these criteria in place will certainly minimize any potential claim that the applicant might have for, discrimination, for example, right? So it will minimize the legal challenge that either the owner or the applicant could raise when you disapprove, right? Because now they see, oh, okay, I need to have XYZ in order to qualify to live in the community. I was denied because I didn't have XYZ. And so, okay, right? So let's assume you've reviewed the application, you've gone through the background check, you've vetted, the whole application, you've confirmed with your good cause criteria, and you know what, this applicant checks out. Great. You can approve the transaction, and typically an approval your documents will typically require some form of certificate to be recorded in the public record, certainly with regards to a sale. So the deed often is recorded along with the certificate of approval if the transaction is a sale, if the transaction is a lease or some occupancy transaction, then typically you can still issue a certificate of approval. Doesn't need to be recorded in the public records. You would just keep it as part of your official records along with the application. Okay. Now, let's presume that this particular applicant just doesn't qualify based on your good cause criteria, right? Well, what could be your good cause criteria? Well, certainly you can consider criminal history. You can consider financial history. You can consider whether there's a violation of the governing document that is reflected on the face of the application. And I'll go through each one of these in more detail in a minute. You can also consider false information included on the application. And you might have other criteria. Okay, but these are some of the more common ones that boards review and consider in determining whether or not to approve an applicant. So with criminal history, you'll have a background criminal report, processed by a third party. And what you need to note with criminal history is that you need to consider the nature of the violation or the criminal conduct, the severity of the offense, how long ago this occurred, as well as any rehabilitation efforts. So it's not a one size fits all situation, right? You have to consider these items on a case by case basis. Now, when deciding whether or not to disapprove for negative criminal history, what you would need to consider is, felonies as opposed to misdemeanors. So you want to make sure that there is at least a felony and that there is a conviction or guilty plea. So an arrest or a misdemeanor charge or just a charge without a conviction would not likely be sufficient basis for disapproving an applicant. Okay. You could disapprove, but just be aware that that could potentially subject the association to a successful legal challenge. Okay. So again, you want to look at, make sure there has to be a felony and a conviction or guilty plea for this to be, for it to be sufficient basis for the association to disapprove without a successful legal challenge. Now, with financial history, the whole point of financial of doing a credit background check is really to confirm whether or not the applicant is able to meet their financial obligations to the association. I would argue this is probably more important if you are reviewing a sale purchase application as opposed to a lease application. Not that it's not important for the tenant to be financially viable, but you have to remember that at the end of the day, the owner is still responsible for the unit, right? And so at the end of the day, if assessments are not paid or the financial obligations to the associations are not met, you're going to be going after the owner, not so much the tenant. Okay. So things that you can consider with financial history could include, for example, minimum credit score. Yes, the board can adopt a minimum credit score, again, provided you even have the ability to approve and disapprove these transactions, right? If you do, I do not typically recommend that you identify the the credit score in the declaration. Rather, just perhaps amend the declaration to give you the ability to determine what that credit score is by way of a rule or a board policy. This way, should market conditions change, the board can either increase the credit score or reduce the credit score requirement without having to go back and amend the declaration, which will typically require membership approval. Okay, so I would recommend having a credit score identified as a separate rule or policy. You can also look at prior prior bankruptcies or delinquencies as part of the credit history criteria. Now, violations of governing documents on its face, that refers to, let's say you are a no pet community, right? No pets allowed. And I'm not talking about your emotional support animals or service animals, right? Because they're not technically considered pets. But if you are a no pet community and the applicant has clearly noted on the application that he or she has a pet, well, clearly, there's on the face of the application, it reflects that they're going to be in violation of your governing documents once they are approved, right? So you can use that as a basis to disapprove the application. And certainly any false information or any misrepresentations that are included on the application can also be considered. For example, if the applicant has indicated that they have never been convicted of a felony, and you pull this criminal background check, and it surely reflects that there's a recent criminal conviction. Okay, that in addition to the criminal history, can be a basis for denial. Now, if you disapprove the transaction, then you will have to provide written notice to the owner and the applicant of the disapproval and the basis of disapproval. And we'll talk about the basis of disapproval in the next slide. But you want to make sure that you provide that timely notice of disapproval so that the application isn't deemed automatically approved if you miss that deadline. Now, we just talked about disapproving for good cause. Please note that if you end up disapproving for reasons other than good cause, okay, so let's say you've decided you've pulled this criminal background report and it shows, a bunch of misdemeanors and some traffic violations, and even though these violations do not constitute a good basis for disapproval, the board's just adamant, no way, Jose, we can't have this individual living in the community. Okay, well, the law says, and this is not something that you're going to find in chapter 718 or 720. This is law that's been developed through cases, so case law. The law says that if you disapprove an applicant for reasons other than good cause, you, the association, will have an obligation to what is known as exercise a right of first refusal and provide an alternate purchaser that will purchase the property under the same terms and conditions as the original contract. Okay, this applies only to sales and transfers. Okay, this does not apply to leases or occupancy, which means that if you disapprove a lease, unless your declaration specifically requires the association to provide an alternate tenant, you don't have a legal obligation to do so. Now, that does not mean that you should be disapproving a tenant for reasons other than good cause, okay, because that subjects the association to other potential legal challenges, but just note that, there's no requirement to exercise right of first refusal for leasing, for leases or other types of occupancy. Okay, only for sales and transfers. Another thing I wanted to point out with right of first refusal is if you, let's say you're amending your declaration to give you the right to approve or disapprove sales. The law says that you have to have a corresponding obligation to exercise a right of first refusal. So that means that your amendment actually needs to say that in the event that you disapprove for reasons other than good cause, you have an obligation to exercise a right of first refusal. You don't have an option to omit this language from the amendment. And if you have declaration that just gives you the right to approve or disapprove sales without that additional language about right of first refusal, then that entire provision is subject to legal challenge and not enforceable. Okay, so make sure that either your current sale approval clause is in accordance with Florida law, or if you are amending to give you that authority, that the amendment is drafted appropriately. Okay, let's go to the next slide. Okay, so just quickly, some potential liabilities. When you consider whether or not to approve or disapprove an applicant, you cannot deny an application based on a protected class. You cannot discriminate, right? So under fair housing laws, protected classes include race, national origin, familial status, sexual orientation, marital status, and there could be more. Okay, so you cannot deny an application based on any of these provisions. Familial status refers to specific age restrictions. If you qualify for an exemption, okay, and you qualify for the exemption because you qualify as a housing for older persons, then yes, you might have the ability to discriminate in the sense that you can deny occupancy to certain age groups, right? Typically, with housing for older persons, there has to be at least one individual that's at least 55 and older. You also cannot deny an application if the applicant is requesting some kind of accommodation or modification. So accommodation refers to an accommodation to an existing restriction or rule. So most common example is if you're a no pet community and the prospective buyer or tenant has indicated on the application that they have a disability and they're requesting an accommodation to your pet restriction to keep an emotional support animal or a service animal. Okay, you cannot deny an application based on that request. Now, you're certainly entitled to perform your due diligence, and under limited circumstances, you can request additional documentation to confirm the disability-related need for that particular accommodation. Okay, but denial of an application simply because there's a request for accommodation made would certainly subject the association to a successful legal challenge. Modifications, sort of similar concept. This is one where the applicant has requested a modification to the common elements, common areas to accommodate a disability. So a very common example is if the buyer is someone that is wheelchair bound and needs to install a ramp in order to be able to access his or her unit, right? There's a process that you should be following in considering a modification request, but you shouldn't be simply just denying an application because a request for modification is being made. Notification requirements. Again, we briefly talked about this. You want to make sure that you review what your requirements are in your declaration as to the time frame for providing a notice of approval or disapproval, because if you miss that deadline, okay, the application could be deemed approved. If you decide to disapprove the applicant based on good cause criteria, you will want to indicate what the basis of the disapproval is. Now, typically, we would recommend that your letter simply indicate that the application is being denied due to the applicant's failure to qualify under the governing documents. You want to be cautious about giving too much information about the basis of the disapproval. And the reason has to do with the last bullet point. Under the Fair Credit Reporting Act and Florida statutes, both 718 and 720, any information that is associated with the sale, lease, approval, or the application process has to remain confidential. So you cannot be disclosing it to the owner or to the applicant, and certainly any other owner in your community. If they request access to these records, they're not entitled. Now, that doesn't mean that these records are not part of the official records. So any documentation that you have obtained as part of the sale lease approval process remains an official record of the association, and you have to keep it. You would just, I would recommend just, filing it in a different location, not with other records that are typically accessible to owners. So for example, credit report or criminal background check, right? You're not disclosing that to the owner or the applicant. Okay, that could potentially subject you to liability. But what you do have to do is disclose in your disapproval letter the information of the reporting agency, okay, that issued that report, so that the applicant can contact that reporting agency and then dispute any information. Okay, so I would encourage you to, discuss your disapproval letter with legal counsel. Certainly, we've assisted clients in even preparing a form letter that they could use for future disapprovals. Okay, so again, encourage you to speak with your legal counsel about that. All right, and then quickly, guest occupancy. Guest occupancy, additional occupants, this is a class of residents or occupants that typically fall through the cracks in governing documents, right? Because they're not approved owners, they are not technically tenants, right? They're just individuals that, are occupying the unit, typically with the owner or tenant. Sometimes they might be occupying the unit in the absence of the owner or tenant. And while you might claim that they are a tenant, the owner is saying, no, 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 they're just, they're my guests. They're not paying me any rent. They're just occupying the unit while I'm gone. Okay. And so if you want to be able to, catch these types of occupants in your documents and give you the ability to approve or disapprove, then consider, discussing this with legal counsel and amending. So some of the things that you want to maybe consider is, how do you want to define guests? Okay, so do you want to define guests so that if they are occupying the unit, whether, especially, in the absence of the owner, they're deemed tenants, and therefore they have to comply with the, with all the restrictions pertaining to tenants, including submitting an application fee, and getting vetted in order to be able to continue residing in the unit. Immediate family members, we briefly talked about this. Do you want to exempt immediate family members from, getting vetted, or from any of these other restrictions that you might impose on guest occupants? Disclosure on initial application. I mentioned this also, typically an application will request that the applicant identify all the individuals that will be residing with the applicant, right? Whether it's tenant or buyer. And so if this particular guest or this particular individual was not disclosed in the initial application, how do you want to deal with that? Non-related guests kind of goes back to, immediate family members. Do you want to provide any exemptions for that? Occupancy limitations. Number of permitted occupancies by non-owners. Do you want to limit how many occupants can occupy a unit, on a per bedroom basis? Duration of permitted occupancies. Registration requirements. Okay, none overnight guests use of facilities. So, these are all just points for you to consider when you're looking for language to put into your amendments. Other practical considerations, member resident surveys. So for example, perhaps you might want to poll your community. If you're just starting this process, you don't have the ability to approve or disapprove anyone, maybe you want to send out a survey in your community just to see how your residents react. For many communities, this is a very touchy subject, right? Many owners feel that the association should not be controlling who can move into their unit, who they can convey title to, and so you might want to survey your community before you actually spend the time and effort in drafting amendments to your documents to address these occupancies. Lease renewals, are you going to allow lease renewals? Do you currently allow them? Do you require additional approval of these lease renewals? Screening additional occupants, we've talked about that. Use of facilities and common elements. Again, you want to talk, this is where your property manager comes in handy. You want to talk about with your manager, establishing rules of use of facilities, especially with guests. Do you want the owner or the approved tenant to be present when these guests or additional occupants are occupying your facilities? There is consideration for, suspension of use rights for violations, right? Just be aware that under 718 and 720, you cannot suspend use rights to, parking spaces, your ability to access the unit or the property, cannot suspend use rights to elevators, okay, and cannot suspend use rights to utility services. Access control, same thing. Perhaps you want to consider adopting some rules and regulations or policies for, vehicle registration program. Maybe you want to institute key cards or a fob system. Gate access, front door procedures, that would apply, for condominiums. So again, just points for you to consider. And then finally, enforcement. So you have a situation where the applicant didn't submit an application. What do you do, right? So, both 718 and 720, outline the procedure for enforcement, right? And typically, most disputes will either require arbitration if you're in condominium mediation, or mediation if you're in an HOA before you can institute a lawsuit, right? So most covenant enforcement will require arbitration mediation before you can pursue litigation. So if we're talking about an applicant didn't submit an application and you want to require them to submit an application, that is a type of violation that you would have to typically arbitrate mediate before you can force compliance through legal action. But if we're talking about removing an occupant from a unit because they've just consistently not complied with your governing documents, then both 718 and 720 do allow for that type of removal to be done through legal action without having to go through arbitration and mediation. So depending on the type of the violation that you're looking to enforce, you might have to do mediation, arbitration, or you might be able to pursue litigation right away. So something you'd have to discuss with legal counsel. Eviction is sort of a category of its own, right? In a landlord-tenant relationship, a landlord has the ability to evict a tenant. But if the association is not the landlord, then the association doesn't have privity of contract with the tenant, and so there is no mechanism by which the association can just evict an unauthorized tenant or a nuisance tenant. The only way that you can give the association that authority to evict is by having that authority in your declaration. And most governing documents, especially the older ones, do not have that that authority in already contained. So it's something that typically would require an amendment to your declaration. Okay. Eviction is definitely a much quicker process to get rid of, these nuisance tenants or unauthorized tenants, because essentially the association stands in the shoes of the owner and can file a quick eviction action to get rid of the tenant. The alternative, if you don't have the authority to evict, is to pursue formal legal action against the owner to force the owner to evict the tenant, right? So that is a much more complicated legal process. So you want to consider possibly amending your declaration to give you the authority to evict. All right, and then denying access to the property or use of common elements and common areas. Again, we talked about that. As a general rule, you won't be able to deny them access to the property. They have to have the ability to still access the unit and still access their parking spaces and still be able to go through the gate. Okay. And then certainly if you end up pursuing some form of litigation, you are entitled as an association to recover costs and attorney's fees. All right, so we're 1 minute or 2 minutes out. So in conclusion, and then we'll wrap this up for some questions, you want to confirm and or create authority in your declaration with regards to all the issues we discussed. You want to establish procedures, proper documentation. You want to act uniformly and consistently, right? So you want to apply these restrictions across the board. You don't want to, request applications for certain types of units, but not for others, right? You want to request applications for all sales or all leases, depending on what your documents allow. And then, consider also resolutions delegating authority to either screening committee or board members, okay? Versus having to adopt, or having to approve these applications at board meetings. So, delegate that authority. And certainly, again, understand the purpose and then the extent of your documentary authority, what you can and cannot do with what you have. All right, that was it. That was the last slide.
Very well done. Very well done.
I'll stick around for some questions now.
Yeah, I know we're a little bit past the time,
fast.
but so while Kerstin and Diane are looking over some questions in the Q&A, I just want to remind everybody, if you haven't already done so, enable that chat feature because you won't see what we placed in there if you haven't already done that. So please enable the chat feature so it shows up. I'll place the link for the evaluation in there one more time. Fill that sucker out. After you submit the evaluation, the required part is over. You can go, but you're more than welcome, obviously, to hang out for some of the Q&A. We'll get to a few of them. We know it's Friday. We know it's lunchtime. We want to get you out of here. We don't want you passing out on us, and we want you to be able to get out early on getaway day. So, ladies, if you want to look over a couple of the Q&A questions in there, I'll monitor the other area, the chat, for any technical issues.
All right, let's see. What can we do about residents renting rooms, as we cannot prove this, but we do know they are renting? Well, first you want to make sure that you have a restriction in your declaration that prohibits subleasing or leasing of rooms. So they are only allowed to rent the entire unit. And not all declarations specifically prohibit this conduct. So you want to make sure, number one, this conduct is prohibited. But number two, you have to compile your evidence, right? So when you send a violation like this to us, the first thing I'm going to say is, okay, well, how do you know this? How can you prove this, right? We're not going to pursue anything in court unless you can document. Certainly you can send a letter, right? There's little harm in sending a demand letter and see how the owner reacts. But if the owner denies, without evidence, we just won't be able to pursue this legally. Let's see, let's move on to another one.
Thanks for the kind words, Dominic. I agree. Kerstin is fantastic.
If an adult moves into her parents' home with the parents living there, can we enforce that new person go through a background check? Again, that's something that you're gonna have to go back to your declaration to see if it allows you to do that, right? Because this adult person moving in after the parents have been approved, is not an owner, is not a tenant, and so you'll likely need to have specific language in your declaration addressing this type of occupancy. You wouldn't be able to do this as a rule or a policy. It would be subject to legal challenge. Okay, let's see. Recently, my management company has decided only to send us a summary of the background search. Their concern is the privacy and sharing of this information. Unfortunately, the summary is not sufficient. I agree. I mean, I don't know how you would be able to make a determination based on a summary. Again, these background reports are part of the official records of the association, right? So you have to have this. But for the reasons I explained, you cannot disclose these background reports, not even with the actual applicant whose background you've just ran.
George, thank you for the movie reference. Stripes was a great one, and I remember that scene. That was
If a resident moves from one pod or section, can you waive in the fee? I don't know. That's something that's going to be very document specific. Can you charge an additional fee for background check if the additional person moving in is not related? Yes, it's currently, for at least for condominiums, the fee is $150 per applicant, except in the event of spouses and parent dependent child. For HOAs, the statute does not currently address application fees, right? But if you want to have the ability to charge an application fee, again, the authority should be in your declaration.
They can set the amount for HOA, right?
They can
There's
set
no
the
max
amount,
for
right? I
HOA.
mean, it has
That
to
was
be.
another question, I think, further down.
Yeah, yeah. I mean, what is a reasonable amount? I
Right.
mean, that's up for debate. The condo permits up to $150. So I would say anything close to that would likely be considered reasonable. Can you really ever disapprove a purchase? Lisa, lots of questions from Lisa. Yes, you can disapprove a purchase if it's for any of the good cause criteria. You absolutely can. And one thing I didn't mention, but just want to kind of circle back on that. The applicant does not have legal standing to challenge a disapproval unless the basis of the disapproval is discrimination, right? So if you're disapproving the applicant because of some negative criminal history, provided it's falls within the criteria I described, yes, they can cry, they can send you, all these legal challenges, but they do not technically have standing to challenge that. It's only the owner that has standing. What about a credit score? We have a minimum credit score and the applicant's below the minimum. I mean, yes, as long as you have the authority to consider credit score in your documents, then yeah, you can disapprove on the basis of a credit score. But I would also caution, I would say this also with regard to credit score. You want to look at the financial history of the applicant in its totality. So if, for example, this is a cash transaction and you know, everything almost checks out, but the credit score is maybe a few points below what you normally require. I would say, you know, disapproving solely based on a credit score might not be a good basis to disapprove, right? So you want to take a look at the application holistically.